Good afternoon and welcome to this webinar on regulating platform work in Europe, challenges and perspectives for legislature and social partners, hosted by the Marco Biagi Foundation and the Department of Economics of the University of Modena and Reggio Emilia, hosted virtually, I would say, but still we're here. This is the second dissemination event of the research project iRel, Smarter Industrial Relations to Address New Technological Challenges in the World of Work, a project co-funded by the European Commission under the Improving Expertise in the Industrial Relations funding stream of the Directorate General Employment, Social Affairs and Inclusion. My name is IACOPO Senatori. I am a researcher of labor law at the University of Modena and Reggio Emilia. And I have the privilege of coordinating this project that addresses the challenges posed by the technological and digital transformation of work on the industrial relations systems of the European Union. Platform work, which is the topic of this webinar, is a widespread and well-known phenomenon, or in the words of one of the national reports that will be presented, is better to say an umbrella concept that embraces different forms of work and different business models. Archetypal examples are the well-known on-demand ride-hailing and food delivery services mediated by apps. I said there are different forms of work that nevertheless share some common features, the most evident of which is the exclusion of the workers involved from the typical labor law protections. In fact, it is still disputed whether these workers can be classified as employees and hence be covered by labor law. As we know, platform-based business models flourished in the past years under the assumption that the workers should be classified as independent contractors, and yet, thanks to the application of digital technologies, be managed, coordinated, and controlled just like normal subordinate employees. While the courts at the national and supranational levels have yet to reach a common standing on this matter, the topic is center stage for institutions and social partners in Europe and overseas. Just a few weeks ago, the voters of California, for instance, the same voters who contributed with a massive 63% rate to the election of Joe Biden as president of the United States, voted in favor of the Proposition 22, which aimed at exempting certain platforms from the scope of a piece of legislation enacted in 2019, known as Assembly Bill 5 or AB 5. A legislation that grants employee status to the workers of the gig economy, to put it very simply. The new bill instead establishes for these workers an independent contractor plus status, as some have defined it, which means, in other words, that the terms and conditions of employment for platform workers would be the same of independent contractors, with the addition of just a restricted number of specific protections. In Europe, to name only the most recent initiatives, the proposals for a directive on adequate minimum wages in the European Union lends a hand to platform workers by declaring that they could fall under its scope, provided that they qualify as parties to an employment relationship as defined with consideration to the criteria established by the Court of Justice, criteria that somehow seem to be more favorable for those workers than the criteria stated at the national level in most of the European systems. On the other hand, the Social Partnership's European Framework Agreement on Digitalization, signed in June 2020, embraces workers employed in activities that use online platforms where an employment relationship exists as defined nationally, without any reference to the European legislation and case law. And this reflects perhaps a weak coordination between the social partners and the rule-making authorities at the EU level. Finally, in Italy, a harsh debate has been triggered in the past weeks by two national agreements for delivery riders that have been signed by different parties and reflect different regulatory approaches. One, we may say, leaning towards the independent contractor plus model, and the other one getting closer to the employee model, especially insofar as it rules out any piecework pay system. So there are many issues on the table and many strategies to address them. We are speaking for sure about a peculiar category of vulnerable workers, and in order to address their vulnerability, we need first of all to know, I would say, their biographies, to understand what their needs are and what risks they are exposed to. We should then investigate which tools and regulatory techniques are most capable to provide adequate protections for them. For example, should they be straightly brought back to the status of employees, or should other routes be explored to integrate their terms and conditions of employment with new and different contents? Can the law and collective autonomy cooperate as sources of regulation of this phenomenon? The questions that opens up the floor for other questions, such as how the platform workers can build an effective collective representation to push forward their interests. By which players, by which organizational forms? This is, as we will see, not just a labor law issue, since competition authorities may want to have a say on it, as one of the national reports that will be presented during this webinar points out. All these questions have a strong policy impact, but they also cross-cut some of the main theoretical achievements of labor law, which makes this investigation even more challenging. Our research team has investigated in the past months how these challenges have been addressed in 7 countries: Bulgaria, Denmark, Estonia, Germany, Hungary, Italy, and Poland. So, the webinar will follow this structure. Today, 4 national reports will be presented by the colleagues from Bulgaria, Estonia, Hungary, and Poland. The presentations will be followed by a discussion coordinated by Carla Spinelli that will be started by 2 members of our research team, Emanuele Menegatti and Vincenzo Pietrogiovanni, and will be concluded by Janis Bellace, President of the International Society of Labor and Social Security Law, whom I warmly thank for attending this webinar. We will then resume the discussion tomorrow at the same time, 4:30 p.m., with the presentation of the second and last group of national reports from Denmark, Germany, and Italy. The second session will open the floor tomorrow to the voices of the institutions and of the social partners. And this is a strategic methodological feature of our project. In fact, we believe that when investigating industrial relations, it is crucial to test the research findings against the views of those who have a direct field experience on the matters at hand. So we will be honored in particular to host tomorrow representatives of the Italian Ministry of Labor, of the European Trade Union Confederation, of the Italian Trade and Services Union affiliated to the Confederation CGIL, and of the grassroots movements Rider Unions Bologna. The panel will also give us the opportunity to learn more about the American experience that I mentioned a few minutes ago, thanks to the participation of Professor Susan Bisenrath from the Thomas Jefferson School of Law of San Diego, and also currently a visiting professor at the University of Modena and Reggio Emilia. And in this regard, I need to remark that we would have been very interested also in listening to the voices of the employers, but I have personally attempted several times to establish a contact with the major associations of platforms and logistics companies in Italy by email and on the phone, but never received a response. And maybe this is in itself a meaningful experiment of the state of industrial relations in this sector, at least in Italy. Now, it's really time to get started. So I will give the floor, virtual floor, the platform, we may say, to my colleague and friend Davide DAZZI from the Institute of Economic and Social Research of Emilia Romagna, who will coordinate the first session. Thanks for your attention.
So thank you very much, Jacopo. I will try to be very fast because we don't have a lot of time. We have to present 4 different national reports. As Jacopo has already said, my name is Davide DAZZI and I work as a researcher in the Social and Economic Research Institute of the CGIL Emilia Romagna, that is a union-related research institute in my region. I'm really pleased and honored to chair this such a high level of group of experts with whom, or at least with a part of them, I've already worked together in some other European projects. My role in this panel is just to coordinate the different contributions in order to respect the timing scheduled for each presentation. As more or less we have to end at about 5:45, so we have more or less 1 hour. I ask each speaker to take about 15 minutes, and in any case, no more than 20 minutes for each national presentation. And as Jacopo Senatori has already said, during the panel, 4 national reports are going to be presented. So the national report on platform work for Bulgaria, for Poland, for Estonia, and for Hungary. And of course, if all the speakers agree, we could keep the same order as the agenda suggests. So I invite EKATERINA, RIBAROVA, and Maria PROHASKA from the Institute for Social and Trade Union Research and the Confederation of Independent Trade Unions of Bulgaria to take the floor and to start their presentation. Thank you very much.
Hi, could you listen to me? Okay.
Yes.
Good afternoon to everybody. Here is already good evening in Sofia. I'm very pleased to share our presentation because we have difficulties from here.
Okay, Caterina, you can start.
Thank you. Go on, please. This is summary of our national report from Bulgaria. We were following the draft structure which was suggested. Please go on the next. Regarding there are not many definitions on platform and platform work in Bulgaria. We summarized some of them. They are mainly identified between some experts, research, in some research publications. One of them is concerning the digital platforms. This is opinion of Economic and Social Council of Bulgaria. There are several opinions of this council concerning the digitalization and the digital work. In some of the reports of our institute, which are based on the desk research, we wrote about crowd work and on-call work. but in general, the definitions of digital platforms and platform work are not very popular at the moment. They are not. It's difficult to find them. Next, please. Concerning the data, we prepared only data from surveys because in the statistics they are not still the statistical institute is not collected, doesn't collect the data about the platform work. One of the survey is made by the Center of Economic Development and agency ESTAT in 2018. Maria was one of the leading persons there. These are the data concerning the platform work. Only a little bit above 3% are involved in the crowd employment. 2% regularly use the service of the platforms for work, and the others either never heard or have heard about the platforms but never visited. The platform work is used mainly for the additional income and for new job opportunities and obtaining experience. It's not the main job for most of the persons which are involved in the platform work. Next, please. Some other surveys, digital labor in Central and Eastern Europe of the European Trade Union Institute. Persons who have tried at least once platform work are only 4.4%, and doing this more often are very, very small amount of respondents. And one other survey in which our institute was also involved, digitalization in the world of work in Bulgaria, Romania, Serbia, and Austria, which was a project of Austrian trade unions. Here is substantial data, 16.2 in total, that online platform exists in some of the working tasks. But be careful, these data are not very correct, because many people don't understand exactly what the platform work is. They accepted every task which is assigned online as a crowd work, for example, or platform work, which is not true. It's in fact rarely used in automotive and in the finances. Concerning the other sectors, it is used in transport, in some of the services, but most of the platform workers either have another job or are students, pensioners, and some other. It's not the main job, as already we saw. Next, please. Legal background and industrial relations players. There is no legal background. For a PT, it's legal background concerning the telework and some other dimensions, but not regarding the platform work. Some of the social partners have their policies, like our Confederation, and some of the employers' organizations, like Bulgaria Industrial Association and Bulgaria Industrial Capital Association. We have some initiatives. One is to establish some links between various kinds of workers at the local level. For example, self-employed, employees, and others in the using online communications. And the other is to try to organize workers from the IT sector. And the trade union is open for any kind of workers, including self-employed. But in fact, it is too difficult to reach the platform workers. Next, please. Under COVID-19, there are interesting trends. on the one hand, we have decreasing of platform work. Is possible decreasing. We don't have exact data for a PT. In some of services, for example, city transport, maintenance, also in finances, but also in some services like catering for homes and offices, we have some trends of increasing, because during the lockdown we did have during the spring, there are a lot of the demand for such kind of services increased, and some of the platforms who work with this increased the volume of their tasks. Next, please. Theoretical issues. One is the alternative forms of employment and alternative labor market and economy, which often are non-formal. This is one of the question, whether this alternative economy and labor market, which is the share of this alternative labor market and economy in the total economy and labor market. The other is what kind of workers are, what is the status of this worker? Is it employed, are they employed, self-employed, or dependent self-employed, which is the main status. And probably I could add here that in some cases when the platforms are intermediaries, we could observe so-called triangle labor relations, like the temporary agency work. The platforms are intermediaries, but they are not real employers. They are another employers, and the platform is only used for both sides to reach them. Next, please. Law and self-regulation. The platform work is not covered neither by the law, neither by the self-regulating social partnership. Social partners have some agreements concerning the telework, the Industry 4.0, but not regarding the platform work. Maybe because the share of the platform work is too narrow. One of the biggest challenge to the trade unions is the isolation of platform workers. Trade unions still are not ready to reach them and to organize them. And which concern the employers, they don't show interest to be represented at this time. Maybe because of the platforms are only intermediaries. Maybe because the share is narrow. There are not as many employers in this area. Next, please. And finally, regarding the European Union policies and law, I think that the most important is that the government paid more, and not only also the social partners, paid more attention on the improvement of the digital skills. Concerning the conflicts, at this moment it's not possible that the platform work could provoke conflicts because it is too rarely used. And in Bulgaria there are some sectors where there are more conflictual industrial relations, like transport and mines. But in this maybe in the transport we could expect some increasing of conflicts, but we will see whether this share of the platform work could increase or not. And finally, the most important things are to make legal amendments in the labor law. At this moment, this is not made. The increased activity of the statistic to collect data on the labor market and the platform in digital work, and also some reform in trade union and employers' priorities concerning this kind of work. In conclusion, platform work is not as much important at this moment for Bulgarian economy and labor market, but it doesn't mean that it could not increase its influence. Thank you.
Thank you very much, Ekaterina.
In case Maria wants to add something.
We still have 3 minutes if you want.
Okay.
Not for the moment. I fully agree with what Katia already said, and maybe later in the discussion. Thank you.
Okay, thank you. So now we are going to present the national report for Estonia. And so I invite GAABRIEL TAVITS from the University of Tartu to take the floor.
Yes, thank you very much for everyone. I would like also to share the slides. I hope I can. Oh, no, it's not true one. Just a minute.
Do you manage? There should be a button on the bottom of the page on the right side.
Yes, we tried it. Okay.
Should be now. I don't know what presentation or something like that.
Yeah, there it is. I hope you can see it.
I think so, yes.
Yes, and now we will do it in a full forward. Yeah, right. Okay, good. Thank you very much for this webinar and for this invitation. And in my presentation, I would like to draw your attention to some specific elements when we talk about the platform work in Estonia. Somehow it seems to be that the situation is quite similar to the Bulgarian situation, but of course there are some specific elements I would like to draw the attention. When we talk about the notion of the platform work, then we have to go back to the year 2016, where there was published the first analysis concerning the implementation of a sharing economy in Estonia. And this analysis, or even research paper that was ordered by the Minister of Economic, it was said that the sharing economy, sometimes we call it also gig economy, it's, as you can see, it is a business model where the goods, services, and resources will be temporarily used, and usually the ownership will not be amended. And also it was pointed that when we talk about the sharing economy, then there are all the time at least 3 participants involved. Those are the, first of all, person who is offering the services. Secondly, there must be also a consumer. And of course, there must be the platform through which everything is happening. Now, when we continue, then starting from 2017 to 2019, there was also the specific committee established by the government, and especially this committee was acting by the Estonian parliament. And this committee has dealt with different aspects of the future of the work, and also the topics like what is the virtual work, what is the legal position of the new workers, and so on and so forth, were dealt with. and especially in the period of those years, 2017, 2019, the different analyses were prepared and also published, and they explained what should be the future of this new ways of working. Unfortunately, it was not analyzed what kind of position would have the trade unions and the employers association in those new forms of employment, and this topic needs even more deeper research. When we try now to understand whether the Estonian legislation has regulated, at least somehow, the platform work, then what one can see is the fact that in Estonian legislation there is no legal definition of the platform work, and basically saying there is also no legal definition what is the or sharing economy or collaborative economy, and this type of employment has not especially mentioned in the law. Still, what we can see is the fact that 3 years ago, 2017, the Estonian parliament wanted to regulate the specific position of those people who are sharing the right services, especially the people who are offering taxi services via the different applications. But the changes in Public Transportation Act, although they were meant to be very modern and very innovative, still stayed on the usual level, which means that the Public Transportation Act didn't say anything special to this platform employment or the platform activity, but they say that that is the way how one can order the taxi using just the normal phone or using the application. So at least the attempt was very good, but when we look what's happening in the legal sense, in the legal sense, nothing has changed. Now, when we look also at statistical data that are available for us, then there is information that at least 8.1% of the Estonian people regularly work via the online platforms, as you can see. And it shows that the importance of the platform employment is quite high. And it is not clarified how those statistical data were collected, because some specialists have doubts that this number is so big, because it was also published by the European Trade Unions Institute, one research paper where it was also researched the platform employment in Eastern Europe. And when someone looks at the statistical data coming from Lithuania, then the difference is quite remarkable, because in Lithuania, for example, the people are using those new forms of employment quite rarely, some 1.6 or even the 1.2% of the citizens. But still, we have to take into account that this 8.9% is not the main job in that sense, but usually, and as the presentation of Bulgaria has shown us, usually this is like the job or small job that the people are doing after their normal working time, and they try to find the new ways how to earn the additional income. But when we still observe the tendencies in Estonia, is that the platform employment is not decreasing. We can say that it is still slowly increasing, due to the fact that especially this delivering service that we have also faced during this COVID-19 situation was growing quite rapidly, and also the people are looking at new jobs, or they are looking the small jobs through the different platforms, so-called gigs, and in that sense it is also quite popular. And also, especially in the case of the COVID-19, where the situation is quite unstable. For example, when someone would wants to open a performance or wants to have a sort of show and invite the people to take part in this show, then in order to find the actors, it is not very easy way, and that's why they are using those platforms in order to find temporary workers. From the legal perspective, again, the situation is also similar to the Bulgarian situation, where the legal status at the moment is unclear, because on the streets we can see there are a lot of workers who are using the applications, especially when we talk about the delivering of foods or offering the riding services. We can see them on the street everywhere, and there is all the time the discussion in Estonia legal framework whether they are employees or non-employees. In case we would like to discuss about the case law, then the case law is missing at the moment, and basically saying also the legislation does not support the idea that those people who are using the platforms and they really do the work daily basis via the platforms, that they could be included into the level. Now, when we turn to the COVID-19 situation, then the COVID-19 situation didn't basically saying decrease the importance of the platform employment, because what we can also observe in Estonia, the delivery services were increasing quite rapidly. And of course, not only the platforms were offering those services, but every other company tried to find new ways to work. But even when we talk about ride-sharing services or this so-called taxi services, then also the taxi services didn't stop. But the people were still using those cars and using their applications, so they still were on the move. And after the specific situation, at least in summer, was a little bit better than it is now, again, those services, ride-sharing or delivering foods, etc., are still quite important. But what was not amended, this was the legislation, and still there is not very intensive discussion about this legal importance of the platform employment and about the legal status of those people who are really using this platform employment. And the one important remark I have to make here is the fact that when someone talks about the platform employment or using the platforms, and those people who are really delivering, for example, those foods or delivering the services, then usually they are students. And what we can see on the streets, they are also from the outside of Estonia, and sometimes from the third countries, because we can also see that especially the foreigners are quite interested in to do this this job. And of course, the discussion is the same in every country, and also in Estonia, that the platform what is using those people in order to make the business, in order to deliver the services, they are not willing to take any responsibility, in the sense that they do not want to be viewed as an employer. Now, when we talk about industrial relations and collective labor law, then the situation in collective labor law does not seem to be better, because at the moment there is no specific trade union that could represent the interest of those platform workers. Also, we cannot observe the very massive collective movement, in the meaning that also the platform workers, they do not try to, for example, to bargain a collective agreement or to conclude a collective agreement. And in case even they would like to have a collective agreement, we have to deal with the rules about the competition law, because there are some, at least theoretical, thoughts about the idea that those collective agreements with the platform workers could be not in line with the competition law, and therefore it would be not possible to conclude this kind of agreement between the platform workers and the platforms or the legal person who is behind of the platform. But still, what we need to keep in mind is the fact that the trade unions, at least at the end of this extraordinary situation that we had in spring 2020 due to the COVID-19, they still raised the question that they are worried about the platform employees and that they would like to start at least a discussion in order to improve the legal situation of the platform workers. In two sense, first of all, in the sense of the labor law protection and also the social security protection, because the social security protection is also the very critical issue for those people who are making income through those platforms. And when we now look into the future, what will happen with those platform workers and how we can still define them in order to be included also to the collective labor protection, then there is idea, and this idea was introduced basically saying 2 years ago, when there was a proposal to amend the external legislation in order to introduce the new category of worker. Although the labor law is not amended yet, still this March there was a Sport Act, which was amended, and in this act, it is quite remarkable. There was introduced a new notion of employee, and as you can see, we introduced the notion of employee with independent decision-making power. So it means that we are slowly, or one can say slightly, moving into direction that in case we have already introduced somewhere a new notion of an employee with independent decision-making power, it seems to be that this will be the future also for the platform workers, because these people are also kind of employees with independent decision-making power, because they can free to decide the organization of the working time and also the place of work and so on and so forth. So we will see whether this general notion of such kind of employee will be also introduced in the general labor legislation. In order to conclude very shortly, I don't see any obstacles that the platform employment will still be regulated in a law, and it will take some time that we can see also the specific legal regulation. Whether the trade unions now would like to take the serious position concerning the platform work, we will see also in the future, but it seems to be at least the trade unions are worried about the legal status of those people. So thank you very much for this opportunity, and I would like to stop here now.
Thank you very much, Gabriel. Thank you very much. Now we are going to present the national report on platform in Hungary. This national report is being carried out by ATTILA Kun and ILDIKO RACZ from the University of the Reformed Church in Hungary, and by Karoli Gaspar of the National Confederation of Workers' Councils. I assume that a person is going to present a national report, and assume that this person is ATTILA Kun. And so I give the floor to ATTILA.
No, actually we share it with ILDIKO, and ILDIKO will start.
Okay, so it's perfect.
Yeah.
Okay, thank you so much. I will share my screen, so just a moment, please. Our presentation. So now I hope you can see the presentation.
Yes.
Right?
Yes. Now, yes.
Okay. Okay, perfect. Thank you. So yeah, today's presentation we divided our topic two parts with my colleague ATTILA. So I will start the presentation, and then I give the floor to him. As you know, if two people want to talk in 15-20 minutes, it can be difficult. So here you can see a short outline of our presentation. Firstly, I will talk about some data about the gig economy in Hungary, and then I will go to the platform economies cast, let's say, the stakeholders. I will show these stakeholders too, and then I turn to the topic of pandemic because it have a kind of effect on platform working here in Hungary. And then I will give the floor to Attila. He will talk about the legal background, the legal opportunities to platform work, and then he will conclude with research results and so on. So let's start it. As you can see, here are some data, and according to our research, the Hungarian adult population making some earnings from platform work, but this earning is quite small. I mean, the number of the people who are working platform work is really small because it's 6.7, which is quite slow, quite a small amount, and it's well below the average of the European countries. I have to mention that the on-demand platform work is mostly localized in the capital city.
Sorry. So just one question: do you manage to show the full screen solution? Because otherwise, we don't manage to read the slides.
Actually, I went to the next slide, so can't you see that?
No, still the slide is very small. Okay, no, it's not solution. You can continue. Just.
Is it okay?
No, I didn't see any change. But anyway, no, you can go on.
Okay, but can you see at all?
Yeah, we can see it, but very small.
Okay, it's interesting. I don't know the reason, but maybe if I just turn my screen out, I don't know, is it change anything or not?
No.
No, okay.
Now, no. Okay.
No. But, sorry for that. I don't know what can be the problem here. Okay, I will continue if you don't mind.
Okay.
Okay. As I mentioned lastly, the main city of this platform work localized in Budapest because definitely there are the most opportunities to platform workers to get any work. Platform work as a phenomenon is immature and hardly visible in Hungary at all. So, as I mentioned, it's not a really high working form, and it is not perceived yet as a separate regulatory employment field, and it is also lacks specific policy attention. Of course, one reason is that because it's not so common at all, and in the last some months, it wasn't the most significant issue. The government and the policymakers focused on the COVID, the pandemic questions to solve that. And now I turn to the platform economics cast. Firstly, I would like to mention two case studies which are related to platform work. First of all, definitely I have to mention Uber because it's the biggest platform. Uber was here in Hungary some years ago. It started its operation in 2014, but from the very beginning, some issues just came into the between the parties because taxi drivers were protesting because they thought that Uber just do the same service like they do, like the traditional taxi service, but Uber doesn't comply with laws, so they do not pay taxes and etc. So that was the main problem. And then Act entered into force in 2016, and Uber then just went out of the country. And there is a Click for Work, which is a platform. It provides work like shopping, gardening, housework, only for students. And students really like to work during this platform because they can get short-term work for quite good wages. So these are the main platforms that I can mention. And then I go to the stakeholders. Firstly, the government started working on some programs which related to the digitalization at all, but unfortunately it's not really employment specific programs. So these programs are preparing the whole nation to know the digitalization, to know use the internet and so on, but these aren't really significant in our topic. And then if I move to the trade unions, I have to mention that firstly, that social dialogue and trade union operation is generally quite weak in Hungary. So it is not a surprise that even in a platform economy, it's weaker than in general. Trade unions not really take care with this platform work question. They organize some conferences, doing some research, but they do not organize the platform workers in general. But we have some, let's say, self-organizing associations which trying to collect the workers or the platforms to have some common aim and gain them. Firstly, I have to mention the Sharing Economy Association, which was established in 2017, and it's collect the platforms, and it's trying to represent their interests. And there is the EVS, which is an ICT organization in Hungary. It is the largest and most significant leading interest group of the information and technology sector. So these are some organizing associations which are not the traditional trade unions, but organized workers or the platforms. And now it's the last slide of mine. So I mentioned that platform work is not really widespread in Hungary. So the pandemic impact on that cannot be enormous either. A lot of shops, restaurants had to close down because of the national closure, and these employers started to using their own delivery services to try to maintain the work, or they just joined to other delivery platforms like Wolt or NetInTM, the Hungarian one. And I have to mention a really interesting association, a cooperative, which was established during the pandemic in order to protect delivery workers from exploitation. The so-called Gólya Futárszolgálat, in English, store delivery service, started to recruit members to form a kind of cooperative. This cooperative is in baby shoes right now, but at least something to show that platform workers try to organize themselves. It can be estimated that the COVID-19 pandemic has brought about the platform economic growth. It's a good thing. So there is probably no issue of income loss, but maybe even income gain in this sector. But as I mentioned, a lot of times platform work is not a really significant part of the employment. So this growth, this income gain cannot be considered a really big achievement in this case. And now I give the floor to Attila to continue our presentation.
Good afternoon to everyone, also from my side. Let me continue by some legal issues connected to platform work in Hungary. Of course, it's needless to say that it would be much better to share a coffee or a glass of Italian wine with all of you now, but we should cope with this situation. Okay, so if I'm talking about the legal background of platform work in Hungary, I should start by saying that it's basically not really a labor law issue. If you're talking about law, it's mostly dealt with tax lawyers and in other fields of law. And as Ildikó mentioned, the Uber story in Hungary from 2016, Uber was kind of chased out from the country for financial and tax reasons, and not really because of the labor law story. So as we can see, labor law is not highly important in this debate. This can also be explained by the very fact that the Hungarian labor law has a very strict traditional binary structure, so we don't have an intermediate third category to cover the gray zones or to cover economically dependent workers. Although in 2011, during the preparation of the currently effective labor code, there was a proposal, a very strong proposal, to introduce a kind of a third category, in-between category, but finally it was not adopted, and this proposal is not on the agenda anymore. So we don't have a third category. So platform workers are either employees with full protection, or they are entrepreneurs with no protection at all. And as we all know, and in most of the countries, also in Hungary, platforms are depicting themselves as only matchmakers. So on paper, platforms do not interfere with the contractual situation. Because of that, most platform workers are, of course, entrepreneurs in Hungary and not employees. And to be honest, it's not really debated. I mean, not on the policy level, and also not in courts. So we, similarly to Estonia, we don't have case law on this now in these days. So it's kind of a debate question. But as you can see, maybe you can see something from the slide as well. There are several applicable legal categories. I mean that platforms and their workers can choose from various legal solutions if they are concluding a contract for platform work. Let me just mention three such very interesting categories. The first one is a specific form of employment, which we call in Hungarian simplified employment. It's nothing else than a form of casual work or marginal part-time work. And I could say that this is one of the cheapest and most flexible way of occasional casual employment in Hungary. Some scholars are saying that this is atypical employment, but the most atypical employment in Hungary. So these workers are employees, but they are belonging to a specific employment scheme, and this scheme is much more flexible than the standard employment relationship. Just let me mention some examples. The minimum wage is lower, they have limited protection, and also the common charges, tax and social security contributions are lower for these workers. So even if they are employees, they are usually belonging to this category. Of course, I don't have a statistical data, but I could guess that most of the platform workers use this scheme for their employment, and they form kind of a second class category of employees. So they are employees on paper, but with much less protection. The second specific category is the so-called household work. Household work is irrespective of the employment status. I mean, both employees and entrepreneurs, self-employed persons, can join into this household work scheme. Household work scheme is a tax category, and it's a special, unique tax category. It's kind of outside of the tax regime, which means that if I am a natural person and I am employing a cleaner or a babysitter or any other natural person via a platform, for example, I shouldn't pay any common charges. So it's again a specific tax scheme to legalize this invisible workforce somehow and opt out from traditional employment. The last specific unique category what I would like to mention, even if a platform worker is a self-employed person, an entrepreneur, there is a chance again for a specific tax category, which is called koto in Hungarian, which is a specific tax category for micro entrepreneurs. It's a lump sum monthly payment, very low and very easy to administer. So it's very handy for private micro entrepreneurs, including platform workers. I forgot to tell you, but all of these specific forms are not designed for platform workers specifically, but platform workers can take benefit from these specific unique categories. So if you are a self-employed person and you are using this quota tax scheme, it is much more preferential than the general tax scheme. So it's again an easy way out of the standard employment relationship and standard taxation of employment relationship. So what is the takeaway from this slide? I would like to mention two things. First, maybe a bit more on a reflective way, that these financial and tax measures can really distort the labor law rationale. I think it's not only specific for Hungary, but it's very easy to opt out from standard employment and the standard tax schemes by way of using these unique categories. Please, the next slide, Ildikó.
Sorry, Attila, you still have 3 minutes.
Okay, I think I will manage in 3 minutes. Thank you. Please, the next slide. Actually, I'm already coming to the conclusion, but it will be a rather long, like 3 minutes conclusion. So as a conclusion, I would like to put forward some, more concretely, 6 or 7 tentative explanations. Why do we think that platform work and its regulation is underdeveloped in Hungary? So I would like to underline and put forward some explanations and reasons for this. The first one, as we have already mentioned, platform work is not really a matter of classification in Hungary. We don't have case law on classification of platform workers. So this whole story is much more about legality. I mean, most of the platform workers are undeclared workers. In Hungary and in many Central Eastern European countries, we have a high percentage of undeclared workers, and there is a guess that most platform workers, of course, belong to the category of undeclared workers. So this is the first reason. The second one is there is a lack of legal clarity. It was mentioned also in Estonia and Bulgaria. I think it's again specific for Central Eastern European countries. In Hungary, as I mentioned, we don't have the third category. We have a definition of the employment relationship, but it's very traditional and very non-operational, I could say. And I also mentioned the several tax and contractual options, which are creating kind of a mess in terms of legal certainty. The third reason for this heavily underdeveloped situation of platform work and its regulation in Hungary could be the lack of the policy focus. I mean that there is no regulatory drive for platform work. It is again a more general story because in Hungary we don't really have a Ministry of Labor, so there are no concepts, no plans for the future, and usually Hungary is more like a follower in terms of EU law than a trendsetter. So I would say that Hungary will wait for any kind of an EU level action before legislating anything connected to platform work. This is just a guess, but I would put a very high amount of money for this guess, for this bet. The fourth reason what I would like to mention that as Ildikó already mentioned, that according to sociologists, the Hungarian society is by default very individualistic, very segmented, and we don't really have strong collective labor law structures. So we don't really have a social civil pressure for the humanization of the platform sector and in general for collective representation. So this is the fourth reason. And the last slide, Ildikó, please, and some other explanations why platform economy and the regulation of platform economy is so underdeveloped in Hungary. I should also mention that in Hungary there are many kind of artificially state-supported non-standards form of employment. Let me just mention one. In Hungary we have so-called school cooperatives in the field of youth employment, and if you are a student and you would like to work, you are almost certainly will use this school cooperative system, which means that they are kind of a concurrent for platforms, and they have kind of a supplanter and superseding effect towards platform work. So what I would like to say that there are many non-standard forms, and platform work is really not the most often used form of non-standard work, because other forms of platform work, other forms of non-standard work like school cooperatives are heavily supported by tax measures and state funding. And maybe I skip one because I'm out of time, and let me just mention as a last explanation or last very general reason, but it makes some sense, that we labor lawyers are saying in Hungary that the standard employment relationship is overly flexible in Hungary, one of the most flexible ones according to data in Europe, which means that there is no real need for non-standard forms of employment. Of course, it's an exaggeration what I am saying now, but what we can really see is the flourishing of the standard employment, because the standard employment can be already very flexible via individual and collective contractual agreements. So these are, according to our study, the most important reasons why platform work is not so heavily debated in Hungary. Thank you for your attention, and I'm finishing now.
Thank you very much. Thank you, Attila. Thank you, ILDIKO. And now, last but not least, we are going to present the national report in Poland. And the national report has been carried out by Izabela Florska and Marta Otto, and they are going to present it.
Yes, hello. Thank you very much. Greetings from Poland. We didn't prepare a presentation because we wanted to avoid all the technical problems, and I would just like to connect what Attila said, that there is no Ministry of Labor in Hungary, and because of this there is not any plan of labor law system. We do have Ministry of Labor in Poland, and still we are lack of the plan. We titled our presentation with a phrase, "A drop in the ocean of regulatory needs." And I will start with presenting the general perspective of Polish labor law market. For over 2 decades, the Polish labor law market has been struggling with a decline in the use of employment contracts as a basis for work. The reason for this pattern is the abuse of so-called civil law contract, and also the abuse of self-employment. What is exactly civil law employment? This is an employment based on the civil code, and such an employment does not guarantee protection for the workers as the labor law employment does. For example, it does not guarantee protection against dismissal or protection of the working time. Despite numerous regulations which are intended to prevent the abuse of civil law contract, the number of such contracts are growing. And also we have to bear in mind that the National Labor Inspectorate has a lot of tools to fight against this abuse, but still it is a huge problem on the Polish labor market. Currently, around 1.3 million people work on the basis of civil law contracts, so it is really a huge number of people who are active on the Polish labor market. The second direction, which I mentioned, is the so-called abuse of self-employment. This phenomenon is partially a result of the state's encouragement of entrepreneurship, and it is being called enforced entrepreneurship. According to Eurostat, there are almost 3 million people on the Polish labor market who are self-employed. There are 38 million citizens of Poland, which means that almost 8% of the population of Poland are people who are self-employed. When it comes to possibility to work via platform in Poland. Platforms which are active on the Polish labor market offer workers two forms of cooperation. First is civil law contract, and second is B2B contract. To be able to sign a B2B contract with a platform, so-called worker has to become an entrepreneur. Since those forms of cooperation are not exotic on the Polish labor market, as I previously mentioned, it is pure reality. They fit into the general trend, and they are not themselves a novelty. The phenomenon of using non-labor law-based employment to platform work is just, as I said, a drop in the ocean of the general problem of the Polish labor market. The activities of the platforms have not attracted particularly both the National Labor Inspectorate and the trade unions. When it comes to National Labor Inspectorate, it just cannot control working conditions of people who are not employees, basically of people who are self-employed. When it comes to trade unions, on the other hand, it is the same pattern as in Bulgaria, for example, as it was already mentioned today. The trade unions do not cover problems of people who are not members of trade unions. And of course, platform workers are not members of such unions. And now some details about characteristics of platform work in Poland. Of course, it's also a pattern if in all countries in which platform work is possible. The majority of people who are performing platform work, those are young people between 18 and 34. Almost half of number of people who are working via platforms are young people, and also a majority of those people are not very well educated. They have either only primary education or lower secondary education. When it comes to Polish workers who work via platform, the pattern is the same as in Estonia. So for majority of people, performing work via platform is additional form of income. Most of those people do have their like first employment, but in a lot of cases, this employment is just not stable, and they want to get more money from additional activities. And of course, also the same pattern as in a lot of other countries. Working via platform is often performed by foreigners. The relatively large number of Ukrainian workers work for Uber in Poland, and it is basically the same as the other Western European countries. And now I would like to pass the platform to my colleague Marta, and she will present the regulatory framework of platform work in Poland.
Thank you very much, Isabella, for passing the platform / the screen. When it comes to regulatory framework in Poland, it resembles very much the situation in all the precedent presentations, namely the fact that the platform work represents rather still rather a marginal phenomenon in the Polish labor market, is very well reflected in the fact that there is no general statutory regulation of platform work. What is even more important, neither Polish legislation but also nor the legal doctrine have provided univocal definition related to platform work. We can find some of those definitions, at least trials to prepare such a definitions in the work of the Institute of Public Affairs, which is a leading Polish think tank and an independent center for policy research and analysis. And the main features of platform work, according to the Institute proposal, they include the intermediation between the ordering party and the contractor on an online platform, the involvement of three parties, namely the internet platform, the client, and the worker, using the online platform to perform specific tasks or to solve specific problems. The nature of outsourcing, which is contracting work outside of the main contractor, and then the division into small parts, tasks, and finally the provision of on-demand services as such. So so far, to quote ATTILA, there is like no regulatory drive to clarify the legal status of persons employed for platform in Poland. In fact, no kind of legislative works, as we managed to confirm with the relevant ministry, are carried out right now. And the only act that covers partially the platform work is the so-called Lex Uber Act, which, due to coronavirus pandemic situation, is in force from 1st October 2020. And it very much resembles, from what I understood, the Estonian Act, similar one. Because basically it is more of a technical nature. It's de facto it constitutes an amendment to the Act on road transport of passengers, which basically defines an intermediary in the transport of passengers, as well as the rules of their operation. So the main assumptions of this act are that all drivers, whether from corporation, iTaxi, FreeNow, Uber or Bolt, they must have a passenger transport license and, of course, the appropriate vehicle marking as such. Fortunately or not, the COVID, as Isa will explain now further on, has not pushed the legislative or policy-making works any further in Poland. And I will pass the platform/screen now to Isabella.
Thank you. And now my turn to tell you a little bit about the COVID situation, of course, in the relation with the platform work. So the COVID-19 outbreak is, in our opinion, like a magnifying glass for all of the pathologies that occur worldwide. And of course, it is also connected with the platform work in Poland. What is still an issue is that the employing entity, which I deliberately do not call an employer, is not obliged to ensure workers who work via platform with any protective measures like gloves or masks. Those people who are working via platforms, they have to take care on their own for the protective measures. There is only one exception from this rule, but it is not a statutory exception. It's just what happened in Poland. Is that Uber decided to make one-off payment to cover drivers' cost of purchasing disinfectants, car blinds, and masks. But that was really an exception, and that was just what Uber wanted to do. What also, of course, happened during the COVID pandemic is that some workers noticed that they have just more work to do, especially food deliverers. On the other hand, Uber, Lyft drivers, especially at the very beginning of pandemic, they could have noticed a decrease in their activity. But all in all, as Marta already mentioned, in the view of number of issues that required legislative activity during COVID pandemic, the problems of platform workers have not been addressed in any way. And now we are going back to Marta, and she will be anticipating the future a little bit.
Yes, thank you very much. I wish I was a clairvoyant in the sense I could really forecast the future. We'll see what I can do. First of all, I think what is important when we talk about the possible regulatory scenarios in Poland is the work of the Parliamentary Group for Future of Work, which is a group that was established in 2019, and as such is composed also of the representatives of employees, employers, and the Ministry of Family, Labour and Social Policy at that time, because we changed the name. So during one of the meetings also the issue of the legal status of platform workers was put on the table, and two regulatory solutions or scenarios were proposed. So first, to regulate employment relations that arise through platforms under the classic employment relationship scheme, and to prepare a series of regulations that would cover the most sensitive areas of employment through platforms that require the intervention of the legislator to protect the rights of employees. Still, the proposed regulatory direction has been met with kind of discontent of some trade union representatives. Why? Because in their opinion, basically the mechanisms that exist already in the Polish legal system that generally aim at regulating the legal situation of persons employed under the civil law contracts may be used to set an example also for other European countries on how to regulate the legal status of persons employed through platforms. So more specifically, in their opinion, by indicating which areas of legal regulations that relate to persons currently employed under the civil law contracts, such as, for example, the right to safe and hygienic working conditions, the right to minimum remuneration for work, or the right to associate in trade unions, as well as the right to be covered by collective agreements, they would rather support an idea of extending the same regulations to cover persons employed through platforms. In general, at this juncture, it is pretty self-evident that the Polish legislator may encounter numerous obstacles when it comes to creating legal regulations for platform work, which primarily results from the fact that such work is not a monolith. So for this reason, it is definitely or difficult to imagine developing one regulatory model that would be suitable for different factual situations. Still, at this juncture, one could imagine, given the legal framework that we already have in Poland, that by using bits and pieces of this framework, and here we pointed out basically to task-based working system, or telework scheme, remote work, which is kind of novel construct under Polish labor law provoked by the COVID pandemic, but also areas of labor law employment which cover people working on the basis of civil law contracts. We could use, again, bits and pieces of those instruments to try to isolate regulatory areas that should also apply to those employed in a platform work as such. Still, until a certain regulatory consensus will be reached between the social partners most importantly, contrary to the kind of common opinion that somehow associates the platform work with the increase in the innovation of the economy, in Poland, they are more likely to deepen the process of precariousness of certain professional groups, precariousness that we understand as certain increase in job insecurity, which is related to reduced quality of work, to lower wages, to lack of social protection, and lack of health and safety protection. And this seems especially the case since you realize that in Poland, the Polish trade union still face enormous difficulties when it comes to organizing workers employed under standard working conditions, which is related, of course, to generally low level of unionization in Poland. And in general, are in the very much initial phase of preparing strategies and policies on digitalization and platform work as such. Looking at the watch, I think I will stop here, and let's see, maybe we could clarify some other issues during the discussion. Thank you very much for your attention.
Thank you, Marta. Thank you, Isabella. Thank you to all the speakers. I think that now we have a wider overview of how platform work is regulated or not regulated, in the 4 analyzed countries, and also we have some instruments also for the future scenario. And your presentation, I'm sure that have arised several questions, some thematic points that I'm sure that they will be discussed in the following panel. So now I give the floor also to the Professor Carla Spinelli.
Thank you, Davide. Good evening. I'm very glad to take part to this conference and to be chair of the present session. And I really thank the organizers who have involved me. I'm sure we all agree, as Davide said, that the presentations were very interesting and full of provoking thoughts. I don't want to abuse the role of chair, but I cannot renounce to underline the main suggestions I got from the papers. First of all, the spread of the phenomenon, which appears still limited in these countries, but especially for this reason, interesting to monitor in its future developments that, for example, Marta has shown us in her last part of the presentations. And moreover, the limited role of the legislator, who has not dealt with platform work mainly within the regulatory framework of labor law, but preferably within other fields of law. And finally, the approach of the trade unions, which seems not yet fully aware of the lack of protections concerning platform workers. I have no time to go deeper into these short remarks because it is on our discussants to offer their qualified comments on the papers. So I give the floor to Emanuele Menegatti from the University of Bologna, who will focus on a really key point of regulation for platform workers, such as wage. Please, Emanuele, take the floor.
Okay, so thank you, Carla. I'm here. Can you hear me? Yes. Okay, then. So thank you very much, Carla, for the floor, for the platform, actually, and for giving this introduction to me about wages, which allows me to move within my comfort zone. So I would like to start from briefly what comes out from the excellent presentation and the excellent reports, and to move to some proposal for the issues involving low wages in the case of platform worker. Basically, we have, according to the reports and the presentation, we have this scenario of weak industrial relations and weak social dialogue, in a context of a significant individualization of labor relations in all the countries we considered so far. So it's not a surprise that unionization and collective bargaining do not exist in the platform sector, and actually this is missing also in countries with a stronger labor law and bargaining systems as well. So not a surprise at all. And in particular, what I realized, and that was expected basically, is that the precarious nature of platform works leads to poor working conditions in general, including very low wages, even pointed out by some reports with also figures about the wages for platform workers. In particular, the right to the statutory minimum wage is denied to these workers from the outset because they are not considered as employees, and or even they are not declared workers, basically in all the countries considered. And even here in third categories and intermediate categories, they don't help because they don't exist, and even where there are special arrangements in place, like I refer to the simplified employment in Hungary or Qatar, they don't help at all with wages. Actually, it's the other way around. In simplified employment, I heard wages are even lower. So they don't get the statutory minimum wage. The collective bargaining is not helping also at all. Not only because trade unions, as we heard, they fail to reach platform workers, or sometimes they don't even are interested to platform workers, but also because given the classification as a self-employed or outside the employment category, collective bargaining for platform workers cannot be taken for granted, as also from a legal point of view. I mean, we know all here that antitrust law is insidious, and according to Article 101 of the Treaty on the Functioning of the European Union, so let me take this to the youth level, Article 101 prohibits agreements between undertaking or involving association of undertakings, which have as their objective the restriction of competition. And a restriction of competition is exactly what the aim of industry or cross-industry level collective agreements. And so, of course, we have the labor exception to antitrust law drafted by the European Court of Justice in Albany. So collective negotiation are possible for employees. However, as again, the Court of Justice in FNV Constant told us, collective agreements setting minimum fees for self-employed service providers are not to be included in the labor exception. So service performed by service providers performing activities even similar to those of employees are in principle undertakings for EU law, and therefore an organization carrying out negotiation on their behalf should be considered as an association of undertakings, and so it falls under the scope of Article 101. So we know that the labor exception actually could apply, so there could be an exception to antitrust law in case of false self-employed, as the court said. And the false self-employed are those that can be considered as worker according to the definition provided by European Court of Justice. I go to the point. In my opinion, the concept of worker provided by the Court of Justice, of course, is much broader than the concept of employee endorsed by national laws, including that in the country we considered. And the concept of worker provided by the European Court of Justice is probably already able to include platform workers inside the concept, because let me briefly refer to it. The concept of worker put forward by the Court of Justice in this concept direction refers actually just to coordination, the casual, on-demand nature of work, like in platform, is compatible with the status of worker for EU law. And at the end of the day, the distinctive feature of a worker in EU law is the functional integration into someone else's business from which the worker is operationally dependent. So basically, platform workers can fit into this definition of worker, and so they could be granted the right to collective bargaining. Even though the European Court of Justice jurisprudence basically could permit collective bargaining from a legal point of view, could permit collective bargaining to platform workers, I believe that EU intervention just to clear the water looks necessary. And actually, the Commission knows it, and in a recent process launched on the 13th of June by the Commission itself, within the consultation on the Digital Service Act package, the Commission wanted to put forward an initiative where EU competition rules do not stand in the way of collective bargaining for those who need it. And the Commission mentioned expressly in those who need collective bargaining platform workers. And so the Commission knows that we need to clarify that platform workers should have access to collective bargaining. And then we have the very interesting recent initiative on minimum wages. We know that the Commission has proposed a directive on minimum wages. And these directives, and I heard that the will of the Commission is to make this directive approved as soon as possible, probably also by the end of the year. This directive can solve the issues, the wage issues for platform workers. Why? Because, well, the main objective of this directive is that of creating a kind of upward convergence of national wage policies. And also, one of the challenges that the directive should face is precisely that of digitalization. The Commission mentioned this problem during the consultation, and digitalization, as the Commission pointed out, has entailed new form of non-standard work, which has increased the share of low-paid and low-skilled occupations and contributed to the erosion of traditional collective bargaining structures. Interestingly, these are 2 points confirmed by most of the national reports. So the increasing share of low-paid worker and the erosion of collective bargaining because of, as an effect of digitalization and new forms of work. So, as I said, the directive could solve the problems related to platform workers, as we listen from the report, because platform workers seems to be included under the scope of the directive, and so they could benefit of the inclusion into national minimum wage statutory mechanisms. Of course, the directive here is not really clear. According to the Article 2 of the draft directive on minimum wages, the directive applies to workers in the union who have an employment contract or an employment relationship as defined by national laws, with consideration to the case law of the Court of Justice. Well, the reference to employment contract and employment relationship probably calls into mind leads to a concept to the national concept of employees, which is, as I said, stricter than the concept of working in the EU, and so again, this could not solve the problem. However, the consideration to the case law of the Court of Justice could work as a way for pushing the notion of employment beyond subordination, and so to include also platform workers, even the countries considered. However, here a clear endorsement of the Court of Justice notion of worker probably could be useful. So probably the wording of the Article 2 of the draft directive could be modified in order to refer to the concept of worker as put forward by the European Court of Justice, rather than the national concept of employment. Otherwise, platform workers, the risk is that they are excluded. The second point, and also the last one, and here I'm going to conclude, because the directive could be useful, is that one of the aims of the directive is to promote collective bargaining on wages in the member states. Without any doubt, a stronger collective bargaining would benefit platform workers. However, here is the problem. As for strengthening collective bargaining, the directive provides a rather vague instrument. We don't know how basically member states should increase collective bargaining. We don't have precise obligation for member states to strengthen collective bargaining. We just get that if the coverage is under 70% of the workers, which is the case of all the countries we consider so far, and of most of the countries in the European Union, actually. So if the coverage of collective bargaining is below 70%, countries should do something like providing a kind of action plan to promote collective bargaining, but it's not clear what they should do. And no extension mechanism has been imposed, is going to be imposed by the directive. So what to do? Probably more tangible tools should be provided by the directive in this sense. And first of all, the meaning of, as I said before, of Article 101 of the Treaty on the Functioning of the European Union should be clarified in order to be sure that non-standard employment, including platform workers, can have access to collective bargaining. And also, the directive can also provide explicit guarantees of access to workplaces for trade unions, even digital access to the workplace, allowing, for example, meeting with workers, pay time off for attending union meetings or for union representatives. So, these are just examples. What my point is that listen to the report, listen to the issues involving platform workers, and in particular wage issues. With this directive, probably we have an opportunity, and the directive should just be improved a bit. I mean, the wording, the text of the directive should just improve a bit in order to not miss platform workers, as could happen. So that's it. Thank you for your attention, and thank you, Carla, for giving me the floor. So the platform back to you.
Thank you, Manuel. Very sharp comments, if I may say. Yeah. And now I give the floor to Vincenzo Pietrogiovanni from Aarhus University, and he will comment the papers from the point of view of the sliding boundaries of labor law. Please, Vincenzo, the floor is yours.
Hello everyone. Thanks, Carla, for giving me the floor. My greetings from the cold and dark Nordic. So I will give my comments to the paper, but I need two caveats first. The first one is that I'm sorry, but I'm going to give some very general, of course, comments on the papers, but also on the papers that will be presented tomorrow. So I'm extremely sorry if I will spoil some of the points that you will listen to tomorrow. And the second one is that I only realized 2 days ago that I had roughly 10 minutes to do this, and I squeezed then all my comments in my presentation. So I feel sorry. I'm sorry if I sound a bit in a rush and a bit unorganized. So I will start with the comparative, a very little and brief comparative view, and then I will do my point on these boundary things that Carla has already mentioned. First, the first point on this comparison that I'm trying to do is, of course, starting from the regulatory framework. We see that the statutory legislation in all the countries is lacking behind. There are only some statutory definitions of platform work or platform workers, and that's basically the case of Italy, which surprisingly, however, refers only to riders, to food delivery workers, and not to other ones, to other categories of workers or other examples of platform workers, and that the sense of it, it's still missing to me. So there is this idea of the legislator lacking a little bit behind. To some extent, this makes sense because, as from Poland, they said the legislative process are usually quite complicated, and we are in the middle of a pandemic, and basically parliaments are almost slowing down very much. But there are, anyways, other signs of life in the regulatory framework coming from other areas. First of all, there are some collective agreements regulating platform work. There is a very recent one in Italy, and the nature and the legal effect and every other aspect of this collective agreement signed by Asso Delivery and UGL is very debated in Italy, and we're still waiting to see what the kind of effects these collective agreements will produce. But we all saw in the reports, we can read in the reports that, for instance, in Denmark, we have collective agreements, the HILF collective agreement, which regulated terms and conditions of platform workers. As well as in some other countries other than Denmark, we have some rules stemming from social security. For instance, in Denmark, again, the unemployment benefits are now connected to the activity rather than just the employment status or the employment relationship. So this somehow proves that there is some resilient activity around platform work in a regulatory framework if we just enlarge the focus outside the strict labor law in terms of statutory rules. But of course, any attempt of intervention from the statutory legislator on regulating platform work is essentially depending on whether platform workers will be attracted to the category of employment or not. Because of course, otherwise, this attempt will be somehow crash on competition law, as in Denmark has already happened with the ILFR collective agreement, which has been somehow questioned by the Danish antitrust authority, and also it's evident in the German report that you will listen to tomorrow. On the classification issues, so first of all, and that's my personal opinion, classification matters, okay? there is no comparable protection whatsoever between an employee and any other sort of categories. So if we just want to somehow cope with the vulnerability that Jacopo mentioned in the beginning, of course, there is already something there, and that is employment protection. In order to do so, of course, we need to argue on what employment is and what subordination is. First of all, though, we need, as labor lawyers, to somehow clarify some myths. The first one is that employment is a rigid legal institution. Employment as a category of work, of employment contract is not at all rigid. Of course, we have ATTILA, who explicitly said that labor law in Hungary is extremely flexible, but the same goes for many other countries. Employment law, labor law in employment protection in the recent years knows plenty of flexibility, in my opinion, even too much. The second point is that many platform workers, especially during the pandemic, have been considered essential workers, okay? So there is a crash here between the idea of essential workers for society and the idea that they are the least paid and least protected and the very most precarious workers. And if you see also about, and if we take a look also at the implication of this precariousness, the implication of platform workers being not classified as employees, then we understand why precarious workers for platforms suffered way more than normal employees, even in the logistics sectors, which can be comparable somehow to the many forms of platform work. There is another point, case law. Now, we know Germany and especially Italy are not fully aligned, but there is nowadays a worldwide trend which clarifies that many examples of platform workers, and when we say platform workers, we of course refer to Uber drivers and delivery riders. These are workers. Most of the times are full employees, even in countries in which there is a third category. Spain, for instance, is one of the cases. So there is a trend. It's probably, the question is why Germany and Italy are not actually following this trend. There is a point also on third category. None of the countries, especially in the ones of the reports, which still have some sort of third category, even in milder forms like in Germany, they have not shown any sort of problem-solving ability here. They're not solving any problem. They're not even able to clarify the legal issues that can be raised by the implication of such work. And one of the reasons is that we have to acknowledge that platforms like Uber refuses even to classify those workers by the third categories that are work. On the contrary, if you look at some case law, and I mainly refer to the British case, which is not part of this research, but it's there and we cannot hide it. Somehow the third category, when it's there and it functions, it plays some roles, it somehow limits the ambition of workers to aim for a full employment protection. So when it's there and it works, it's actually counterproductive, if we will. The last point on the classification is connected to the Danish HILF agreement, and that is extremely fascinating because according to the collective agreement, it's up to the workers, the platform workers themselves, to choose whether to be classified as employees or self-employed once they meet a requirement. And this is, of course, really interesting coming from a country in which we all know that, Italy, of course, where we all know that it's only up to the judge to classify. We have this idea of no one else than the judge be able then to classify and to say what kind of contract there is between two parties. On the empirical dimension, we have very little data, sometimes not really up to date. So I wouldn't really rely on those figures, actually. And I think that during this pandemic, many of those figures will be changed. So I think that in the future, empirical research will show that in the last 10 months, the reality of workers for platforms has changed. But generally, we can say that it's marginal if we look at the labor market. It's only a small percentage of it. And in some countries, like Hungary or in Poland, this platform work is not even an issue. It's not even the issue, because they are facing larger problems in general terms with informal and black work. Work at black. It would be interesting, though, to understand why, even though it's marginal pretty much everywhere, why it is marginal more in Central Eastern European countries than in Western European countries, where, as ATTILA has underlined, labor law is extremely weak. You know that, I mean, politicians in those countries, they believe that any sort of employment protection is a synonym of communism. So they are very keen on avoiding having, strong employment protection there. On the yes.
Sorry.
2 minutes left. Okay, so I will. 3 minutes left. Okay, so I will jump. But the thing is that, and then I will move forward. Even though it's marginal, it's not only platform work. It's not only that is about the future or about the process of taking our analysis where something happens in the first place in an embryonal thing. The problem is that if we look at the strategies of platforms, IACOPO mentioned prop number 22. If we look at the strategies, they already said that prop 22 is a test that will be applied not only in other states in the US. There is now a campaign in Illinois going on to move forwards and this kind of independent contractor immunity. But it's going to be launched all worldwide. So I think that in the future months, we will see a lot of lobbying activities and a lot of advertisement on this. My point is some sort of theoretical, methodological. I think that already from these very short reflections, we can see that one way of understanding, reading platform work can be the lens of boundary. Okay, the idea of boundaries. These companies, Uber, Foodora, Deliveroo, declare themselves as tech companies, but the quality and the level of technology they use and they develop is extremely poor. So within the tech sector, they are extremely on the margin especially if you compare it to Google or to Amazon. The labor involved in their services is completely outsourced. So once again, the labor is put outside at the boundaries of the platform's responsibility for social transactions. Platform work functions outside labor law or at its periphery with contract law and company law. However, the reports have shown clearly that these tensions with these areas of law, sometimes extremely close to labor law, neighbors of labor law, like in social security, can give some sort of response. Of course, tax law, transportation law is also important. But if we look at company law or at white civil law or competition law, we see that legal institutions like abuse of rights or abuse of dominant positions, which can be understood as teleologically close to labor law institutions, can actually also work for the better. Another empirical understanding from the report is that these jobs are usually attractive to persons who are the outsiders of the labor market, at the margin of the labor market, sometimes even at the margin of society, like migrants or cross-border workers in the case of Germany. And in this point, I have a suggestion, maybe for the future, since as you will listen tomorrow, German has this issue of cross-border workers, I guess from Poland. Maybe it's important to understand how, from the Polish perspective, this can be understood. So the point is that platform works at the boundary of labor law. Nonetheless, it calls for a reconsideration of the very core part of labor law. The concept of subordination, the concept of time, what is working time for a platform worker? And you know, the Yodel case at the Court of Justice was exactly about that. And also the collective labor freedoms that should be enshrined to all workers according to the ILO Convention. And when we define this, we actually are doing what in Italy, using the Italian expression, we say actio finium regundum. We are defining the boundaries of the scope of application of labor law. In my opinion, we need to overcome these boundaries. We need to go even farther than that. And that's why I think that our research, and I hope we can adjust this in the future, lacks some reflections on the quality of technology. Now, I've read yesterday of this proposal of directive from a member of the Parliament, of the European Parliament, Leila Shaibi from the European United Left, which proposes a regulation of platform work. One of the essential provisions is about algorithm. I think that it's important that we address, that we focus our attention on the technology, okay? So my suggestion is to address, of course, the policy and the regulatory issues of technologies and the companies that develop or use this. Now, I know that I don't have so much time, but there is already something going on at this level, suggesting the fact that algorithms at large artificial intelligence deal with questions of ownership, with questions of design, and with question of governance. And there could be plenty of room there for trade unions and political decisions to regulate technology. Which I would just mention, and then I will shut myself, it's the fact that in regulating algorithms and in general digital technologies, we need to insert a public interest. And it's not something completely new. It's not something completely revolutionary, if you wish, because it happens, for instance, for pharmaceutical products and for pharmaceutical companies. The fact they produce pharmaceutical products, so something that is potentially dangerous, it's somehow connected to some authorities made by experts, not only politicians, but also experts in ethics, experts in law, experts in other fields, that somehow evaluate, assess the potential impact of artificial intelligence, algorithms, and digital devices on human rights and fundamental rights at work for what it concerns labor law. Thanks a lot. And sorry if I was a bit longer than I should.
Thank you, Vincenzo. Your intervention has certainly added food for thought. Now I kindly ask Professor Bellace from the Wharton School of the University of Pennsylvania and President of the International Society of Labor and Social Security Law to conclude this session.
Thank you, Carla. Thank you for the invitation to speak to all of you. I wish we were in Modena today, perhaps next year. I've been fascinated over the past 5 years that the topic of platform work has dominated labor law conferences. And you might say, why? Well, it's obvious. There's a perceived problem. Platform workers often are not deemed employees. Well, then you say, what's the problem with that? And then several problems come up. Firstly, they escape the protections afforded employees. Minimum wage has been mentioned, number of working hours. Do they receive things such as disability insurance? And the list goes on. This not only makes their personal situation more precarious, But it also harms society, that a larger and larger segment of working persons now have their overall conditions of work pushed down. The second thing to realize, and we must say this bluntly, is they are cheaper labor. The reason why owners of companies are using this form of employment is because it's less expensive for them. Usually they don't have to pay all these contributions to the state and taxes, etc. It's cheaper for the owner of the company. And therefore, and this is important for the entire labor market, it reduces the owner's use of traditional employees, and people who would like the status of traditional employment see that there are fewer opportunities anymore, that they're being pushed into this non-traditional area. That's another danger to society. Of course, unions, the traditional means of supporting workers' interests, are in a difficult position. In some countries, labor law does not accord collective bargaining protections or rights, if we use that word, to non-employees. This does not meet the standards of ILO Convention 87 by any means, which uses the word workers. But that's the case in some countries, that these people are pushed out of the collective bargaining rights area. Even if they are in the collective bargaining rights area, it is still difficult for unions to organize such workers. And traditional collective bargaining, which relies on the threat of a strike, sometimes falls apart because strikes seem difficult. Like, how would one organize them or at least sustain them? So we see the problems. One of the questions that occurs to me is, why do judges permit the owner of the company to determine the relationship? And to, it's sort of like a negotiation. The owner of the company says, this is the relationship. And then judges seem blinded at looking at the reality of what's going on. To take one example, Uber drivers versus taxi company drivers. They both drive cars. The users of the service look to the company, not to who the driver is. They select the company. The company identifies the customers. The company hands out the work to the drivers, and the company sets the price. That's the reality. So why do judges hesitate to call Uber drivers employees? By the way, I agree with the point that Vincenzo just made, that for a company to say, I'm a tech company because they happen to use a supercomputer and platforms is ridiculous. And the real tech companies, such as Google or Microsoft, they do classify their workers as employees. So this is the most ridiculous claim. The people should say that it's absurd. So getting back to, why do judges think these workers are not employees? Well, firstly, judges apply a statute, and we know that the statutes were written before there were such things as platform workers, and therefore they're not written in a way expressly, or rather deliberately, to include them. Also, judges have notions in their head of what defines an employee. It's based on industrial notions of factories. The judges are using outdated notions. They're trying to squeeze 20th century workers, the organization of work in the 20th century, they're trying to squeeze it into old boxes. So one of their notions is control. You know, in a traditional employment, you're told when you must show up for work and when you must leave and how many hours a week, or what type of, piece rate, how you define that. So if you don't seem to fit that control, judges say, well, you're not an employee. But we can think of examples a century ago where people didn't meet that level of control and they were deemed to be employees. By the way, I hate to use the word temporary work because in Europe it means something, but in the United States, temporary work meant if a person's secretary went on vacation for a week, they would call up the temporary agency and say, can you send me a secretary for a week? that type of person who had the choice to turn it down, that type of person would tell the temporary work agency, oh, I don't want to work that week. My children are on vacation. I don't want to work. That person had the choice to work. They were always considered an employee. Nobody ever said they were self-employed or independent contractor. Another factor of control, or what's the notion of the traditional employer? The traditional employer supplies the equipment and the place to work. Okay, so a platform worker may own their own computer or their own car, like Uber, or their own bicycle, like Grubhub and these delivery services. But a century ago, skilled workers, such as carpenters, owned their own tools, and they were considered employees. So you could see that some judges seem to be mentally locked into outdated notions of what constitutes employment. And I would also say some judges in some countries seem to favor notions like entrepreneurship. They like individuals having freedom over anything collective. And so they tend to tilt towards this work arrangement, and they sort of latch on to small pieces of choice and say, oh, well, that's not employment. And also today, many people are ignorant of how workers who years ago did not fit neatly into the employment model were deemed employees. Matt Finken and I, those of you who know Matt at the University of Illinois, we were talking about this. And recently, by the way, I was writing a chapter for a book, and I brought in a 1944 Supreme Court case involving what were called newsboys, the people who stand on the corner and would sell newspapers. And Hearst Corporation, a giant publisher, said, oh no, they're not employees. By the way, that's the corporation, that's the persons in Citizen Kane. I won't go into the details, but the court, at least in 1944, said, well, we look at the whole relationship and we look at how the company sets important aspects of it. This is employment. And I think that's what we need judges to do today, to look at the entire arrangement and say, who has real control here? So what's the real control? Well, my view, it's two factors. Who sets the price for the work or the service? That is, how much is charged the customer? If you ask for your sink, the basin in your house to be repaired, is the person who comes, is he an employee or is he self-employed? Well, the question is, how much is he charging to fix the sink? Who determines that price? And the second key is, who determines how much the person who does the work will receive for performing the work? So take my plumbing example. The man who actually does the work, does he decide how much he keeps and how much he'll spend on other aspects of his business? Or does the company decide how much he will receive? Those are the two keys to decide whether we truly have an independent contractor, a true self-employed person determining these, or whether another entity, the company, is determining it. So the issue is looking forward. How do we define platform work versus digital work versus gig economy work? In different countries, different terms are used. Consider that in 20 years' time, many of us may be platform workers. We work at universities. We may have everything assigned to us through a platform. We may have no department chairs. We may be delivering our work over the platform, and our university will be the owner of the platform. Many aspects of our work may be controlled by a platform. So we all may be platform workers. Does that mean that we're not employees? Most of us will be digital workers even today. How do most of us work? We sit at computers. Some of us will be gig workers, but that's different. That's a very precarious category of work. And I'd almost like to discuss that separately. Not that they are not employees, but that it's precarious and that there are ways that in the 20th century, some unions found to make that precarious work more stable. Now, how does the law give workers subject to these new technologies voice and protections? That's what's really important. The protections are important, minimum standards, a social safety net. That's important for society as a whole. And to say, oh, they're self-employed, they will take care of themselves for their old age, and if they should become disabled, frankly, is sticking one's head in the sand. It will be a big problem. In my view, they should be defined as covered, and we can look to various existing unusual situations to figure out how we do contributions for a social security system, such as workers who move around in the building trades, such as musicians. But define them as covered. And the other one is voice. Traditionally, that was collective bargaining, and we have to consider how our notions of collective bargaining can be extended to these workers. Now, though, we could easily do consultation rights and disclosure of information because we have the technology. It's easier now with Zoom, etc. These are the things we have to look at as we consider the role of labor law in supporting working people, because these people are labor, they are not capital. And we could put labels all over it, but I think most of us realize that they are workers who rely on the wages, and it is wages they earn. They are not really a business. And we have to cut through this artifice that some very large platform type companies are spending. And at the end, Vincenzo mentioned Illinois. When you look at the California referendum, the platform type companies spent $200 million to get support to defeat that referendum. This will indicate where the interest of the owners of capital lies. And it is a duty of labor lawyers to work in the interest of working people. Thank you.
Thank you, Professor Bellace, for your brilliant conclusion. I think there's really nothing more to add, apart from reminding you all that the conference goes on. Tomorrow in the afternoon, we will have the second session, and we'll gather again at 4:30 p.m. So thank you to everybody, the presenters, the discussants, and the participants, and see you tomorrow, and goodbye.